trying to refresh their memory of, maybe they sat through a class where this was once discussed, but that we do have a variety of constitutional obligations, and start to try to encourage them to actually fulfill the constitutional obligations that we all took the oath to say we're going to uphold in both our state constitution and the federal constitution. And I loved what you had to say about it. Drafting a bill is what we do in an effort to educate the public. On the Massachusetts law, that's a wonderful idea. I didn't know anything about it, and is often the case of what happened. You sit through these things. Gene and several other people sit down and talk to us about the Vermont law. We start talking and come up with a different approach, which I think is what Wisconsin is now doing. And I'm going to go back. If you can give me afterwards the citation for the Massachusetts law, and to start to look at that, at whether or not we can do that legally, or in some of our states just push the Attorney General to go about and doing it. Jamie and I spent half an hour on the cell phone on the way down here talking about pushing our Attorney General on on other issues. So
I had a hands-free device.
We both had hands-free devices. Driving in the District of Columbia, we were both on hands-free devices. So, but that is an excellent idea to follow up on, to see if we can start doing this, to try to then force the governor, because in often cases it's easy for a governor just to say no, I don't want to do it, but that could change the dynamic more.
Do you want to call him?
Sure, go ahead. Are we doing the 3 questions again?
Let's do that, yeah. And I call on that side this time, so.
And did you get a time? Do we have a time?
We have about 10 minutes left.
Okay, sorry.
I'm a law professor, and I'll make 2 pedantic points and then a question. The case you want to look at is Massachusetts versus Laird, which unfortunately declared the Massachusetts action unconstitutional, but it discusses that. Secondly, there's a case which almost no one ever mentions called Fleming versus Page, a Supreme Court case in the 1850s in which the court said in dicta that the Constitution does not authorize offensive war by the United States. Never mentioned. It involved pensions, but it was mentioned. Then a question maybe to Jamie Raskin. Standing. Would a governor, because the court often strike down these attacks saying congressmen have no standing. Could a governor have standing, given, say, the sort of revolution of statute that states are contemplating to challenge, the improper action of the federal government? I don't know the answer. I'm just asking.
We'll do the 3-question routine again.
Could you repeat the sense of the question, please?
When we get up, we'll do that.
Yeah.
Yes.
As people who are politically on the front lines, you probably more than the rest of us are acutely aware of the cultural wars that are still going on and still vehement and find ever new forms of expression. You also seem to, at least all 3 of you, seem to champion the idea of this island called the Constitution, the law of reason, enlightenment. Share some experiences about what's most acute on the cultural war side and how you see a breakthrough there. I understand the legislative idea, get the bill out there, get the idea going. But underneath that, and larger than that, is an ongoing cultural war, or what is called cultural wars, plural.
Yes, ma'am.
I just wanted to get some feedback about what has been the reaction among your colleagues to these legislative proposals.
Did everyone hear that question, the feedback of colleagues? And
Yeah, I mean, your other colleagues who aren't here, I don't mean.
Yeah, no. If only it was just us.
It's not?
Yeah. Well, it's been interesting because I think it's there are multiple strains. One is we're a state. This is a federal responsibility. Let's not involve ourselves in this because it's not our purview. One is what you heard Mr. Halpern talk about. When it's a policy of a president of our party as opposed to the other party, then of course this is something that we need to stay quiet on. We can't possibly embarrass the president of our own party. Some of it is they're completely unaware. I mean, this is the first time, and I would say for a lot of people on this issue, this is the first time that they've really started to think about these issues because they are state legislators, and we rarely get into defense policy, total force policy, those sorts of issues. We've never discussed before. And I think, and this is, Gene and I were talking about this earlier, they get very, I think, easily dissuaded by any roadblock that comes up. The Attorney General's office in our state provided some advice saying, oh, this measure was most likely unconstitutional. And so it became an easy way to say, well, then let's just put it aside, as opposed to, well, let's understand what are the constitutional concerns the Attorney General is raising. How can we address them and move forward with something that in fact is constitutional in a way that allows it to move forward, but then that would ask for an effort. And on many issues, we look to avoid anything that we can. So I don't know if you want to. I already tried one, and my only answer to your question about the culture wars, and I try to say this to people all the time, is in our system, the government doesn't change the culture changes, and then the government also responds to it. I mean, Vermont did not create civil unions and gay marriage. It wasn't like someone in Vermont one day stepped forward and said, I have this great idea, like two men or two women form some sort of legal partnership. It was the fact that there were increasing numbers of same-sex couples living lives who started to find they needed these protections, and that the culture changed. The government then, the law changes to reflect the change that's happened already in the culture, in my view.
I guess I have just a word or two more to say about culture wars. All three of us have mentioned marriage equality, and that's the place where, when you ask the question, sort of the stark different sides shows up. Is most recent in my mind, and I do think it's important to say. I mean, we come to conferences like this. People who come to conferences like this, or are online on conferences like this, tend to agree with us. The three of us have asked for a crazy job where we have to work really hard at getting along with people who really disagree with us. And so there is a real diversity of opinion out there. And I have to tell you that I do have a whole population of folks in my district who are furious at me around marriage. And their anger is, particularly around marriage, they would be angry about other things if they weren't for marriage, but their anger, though, is not irrational. It's not something that I can talk through with them. I mean, I try, but it is one of those, on that issue, a very deep-seated, deeply held belief that sort of wraps into a whole worldview. So that's just part of the dilemma of our job, part of the work we have to do. And I think there is a give and take. I think it is. I think Rich is absolutely right. Generally, leaders look where the crowd is going and try and hustle and get in front. But I think also it is our responsibility to say, no, this is the right thing to do. And I know people will be mad at me, and I know that I'll lose votes over it. Generally, people respect you for that. They might not vote for you, but what is the reaction amongst colleagues? I can't remember who asked the question. This on a certain level, Gene Athey says it so well. This looks like a no-brainer. How could this be hard to pass? We're just asking for a clarification about what we all believe is current law. That a governor has to follow the intent and has to certify that a federalization order is legal before releasing the guard. On one hand, I agree. We've made it into a pretty simple sounding argument. On the other hand, it's an incredibly radical thing to ask for a state's voice in military policy. And as Rich just said, it's something we're not used to doing. It's something that many of us would like not to do, like to not have to do. So while I joke about us being in a race to be the first one to pass it, and we're going to work our pants off to try and pass it somewhere, it's a big challenge. It's a very big challenge.
I'm sure most people have noticed that America's public infrastructure is eroding and collapsing everywhere. We think back to Katrina. Louisiana and Mississippi saw devastating damage because of the hurricane. Well, I guess it wasn't really the hurricane; it was the levees that didn't work, and there was no public infrastructure to deal with the crisis. Well, that was a multi-billion-dollar crisis, hundreds of billions of dollars crisis, and National Guard units in Louisiana and Mississippi were abroad. Many of them were abroad. The governors could not address the crisis there, and these kinds of things are going to be getting worse with global warming. So the question is rightly asked, well, would a governor have some kind of standing to challenge an unlawful deployment of federalized National Guardsmen and women where a member of Congress would it? And I think the answer to that is yes. We don't know the answer in terms of positive law and what the courts might say, but I would say it's clearly very different from being a member of the lawmaking branch, which is arguing, say, that the authority of Congress has been overridden, and the court has always wanted to say that that's a political question, or that, I think in the Dellum's case, that the members of Congress lack standing to challenge the action. But, I mean, if you tease out the argument that the states that we're starting to make now, which is that we understand the constitutional design permits the federalization of the National Guard troops in times of a real national crisis when Congress is acted to declare a war, but nothing beyond that or nothing outside of that, why wouldn't a governor say, we need those National Guard troops at home and it's time for them to come back? And we insist upon our power and our right to recall them. I mean, that strikes me as a meaningful and viable and serious claim about rights that states maintain under the Constitution against federal power.
Senator Raskin, I make a quick correction. The levees held. We also have flood walls constructed by the Corps of Engineers. They were poorly constructed to make a lot of walls.
Can I also make a quick correction?
Absolutely.
The law, the Massachusetts v. Laird case did not declare that the law that was passed by the state of Massachusetts was unconstitutional. Rather, the Supreme Court said that Massachusetts did not have standing to bring the case and that it was a political question. But that doesn't bar other states today from issuing the same kind of laws and issuing these cases to go forward and have the courts be active arbiters of these basic questions, whether these laws are constitutional, absent any declaration.
So thank you, everybody. I think we're going to take a 10-minute break before we do our the next speaker, and I'll be around for a while, and I think Jamie and Rich will be around for a little bit to answer any other questions. So thank you, and get yourself some more coffee and bagels and whatever.